Has Mr. Strickland spoken? Has he spoken to his attorney yet?
No, he hasn't.
Okay. She's in a breakout room with another person, and as soon as she's done with that person, I'll put you in the breakout room with Mr. Strickland. So it'll be a few minutes, okay?
Okay, sir. I just want to let you know he's not consenting to do a video arraignment.
So what is he consenting to do?
I'm getting him his paper. Is there any paper clips or anything?
Oh my God.
Yeah.
Okay.
Yeah. This is the court, sir.
I don't consent to the thing. I'm asking why they can't bring me court.
Okay, hold on. Does he want to speak to an attorney first?
Yeah, well, let's have him speak to an attorney first. You have to speak to an attorney. You have to.
Hold on. Mr. Strickland, can you hear me?
I don't need an attorney.
This is the judge.
Okay, Mr. Strickland,
Open the door.
can you hear me?
Can you hear
Oh,
me?
you don't want to hear me.
Sir, can you hear me?
What?
Mr. Strickland, this is
All right.
Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand? I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity. So y'all trying to run a lien on the name, that's illegal. Who are you trying to conversate with?
These individuals never seem to realize that they are actively sabotaging themselves at every step. An arraignment is not a debate stage or a protest forum. It is a procedural gateway. If your goal is release, cooperation is not optional, it is essential. Courts are built on process, not personal belief systems or internet theories. When someone intentionally refuses to participate, they are effectively choosing detention. The system does not bend just because someone demands it loudly. In the end, their resistance only guarantees the opposite of what they claim to want.
Entity through the Secretary of State and the federal government. Here it is right here, the Secretary of State,
Okay. Sir?
It's right here, Lincoln. To the flesh and blood or the name inside. I'm trying to ask.
Sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you speaking with? The flesh and blood man or the name entity? I'm speaking to
both of y'all. I'm speaking to both of y'all at the same time. How about that?
You can't. Now,
sir, I know you want me to release you.
Here it is.
Are you gonna let me talk?
Here.
Are you gonna let me talk? Sir?
Sir?
Are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down,
Don't
sir.
consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yes.
Want to release you, the entity, or the person in the flesh? Which one?
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right, now.
For UCC1. Everything.
If you don't, When I talk, you listen.
Ma'am.
If you don't want to talk to an attorney and you don't want to be arraigned today, we're going to put you over to tomorrow. You understand?
That brings the first courtroom encounter to a close, and nothing productive was accomplished. The judge clearly signaled that another opportunity would be provided the following day. This is not generosity. It is procedural fairness. Courts routinely give defendants multiple chances to comply. Whether the defendant takes advantage of that opportunity is entirely up to them. History shows that sovereign citizens almost never adjust their behavior. As a result, tomorrow's hearing is likely to end exactly the same way.
5-6. This is the Township of Ypsilanti versus Shannon Phillips.
Hi,
Hi, can you state your name for the record, please?
Shannon Phillips.
Okay, thank you very much. So today is the date and time set for an arraignment in this matter. What I have here is a citation from May 27th of 2024 that charges that on or about that date you did operate a motor vehicle on E-Course Road at or near Harris Road with improper plates. It says that the plate did not come back to the vehicle that it was on. That is a misdemeanor with a maximum penalty of up to 90 days in jail, a $500 fine with court costs, or both. Do you understand all that?
No, I do not understand.
Okay. So let me clarify. When I ask if you understand, what I want to know is, do you know now what you are being charged with, whether or not you agree with it?
No, I do not agree with it, and I filed
Okay.
paperwork to the court
Yes.
expressing that.
Okay, and I'm cutting you off for a second because I'm not asking if you agree with it. I'm just asking. I have explained that you're being charged with having improper plates. Do you understand that that is what you are being charged with? Again, I'm not asking if you agree with it. I just want to make sure, because the purpose of this hearing is to determine whether or not you are competent to stand trial. That's part of it, at least.
Now the focus shifts to another courtroom with a different sovereign citizen ideology on display. Despite different personalities, the playbook remains identical. Refusal to engage, rejection of basic legal concepts, and endless philosophical rambling dominate the exchange. The defendant appears more interested in asserting identity theories than resolving the case. This pattern consistently prevents progress. Instead of moving toward resolution, the case becomes needlessly prolonged. Once again, the defendant cannot get out of her own way.
You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. You do not have to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if these proceedings would have any effect on your citizenship status. If that does not apply to you, then do not worry about it. So, do you wish to have the public defender speak on your behalf?
No.
Okay. In regards to the misdemeanor charge against you, how are you pleading at this time? Or are you standing mute?
Standing mute.
Okay. I am going to set this for a...
Ma'am,
Yes.
this has been long and drawn out since, May. I don't even have that vehicle anymore. Unfortunately, I've had to buy 2 vehicles since that vehicle. Not to mention how aggressive and threatening your officers was.
The moment where basic understanding finally appears is almost shocking. After extended confusion, the defendant acknowledges what is plainly written on the paperwork. This demonstrates that comprehension was never the real issue. The problem has always been defiance disguised as confusion. Courts do not require agreement, only understanding. Even minimal cooperation moves the process forward. Unfortunately, this moment of clarity is brief and immediately undone by continued resistance.
Use my phone.
Okay. Before you continue, couple of things. One, I will note that the officers are not court employees, so they are not the court's officers. What I am going to do, because it is the next step in this process, is set you for a pretrial. Okay? The purpose of the hearing today is to make sure that you know what you're being charged with and what the potential penalties are. The next step is a pretrial, which is where you will get to discuss with the judge more of what happened that day, and if you have evidence, then you can bring it up then. Your pretrial is being scheduled for November 27th.
11/27.
Correct. This year, so that's 11/27/2024. That will be at 9 in the morning over Zoom before Judge Washington. Because of your appearance here today, I am recalling the bench warrant that issued for your arrest on October 9th. That bench warrant had issued because of failure to appear for a number of arraignment dates that were set.
But I was there, and I have proof of that as well. I was on the hearing. It did the same thing it was doing now, saying that the host was there and would let me in. But I sat there for over like 2 hours.
Complaints about police conduct often ignore the cause and effect relationship of the situation. When officers issue lawful commands, refusal escalates encounters rapidly. The defendant's expectations of consequence-free defiance are unrealistic. Police interactions are governed by law, not personal comfort. Video evidence rarely helps when it confirms non-compliance. Courts view these situations through an objective legal lens. Emotional reactions do not override statutory authority.
Okay, so to be clear, the bench warrant is being recalled, so that is going away.
Thank you.
The court is setting a personal recognizance bond, so basically you're promising to appear for the next court date. Again, that's November 27th. I will note that sometimes, depending on the size of the docket, it can take a long time. And I think my arraignment docket last Wednesday took 3.5 hours. So it can take a long time. So long as you're seeing the message that the Zoom is still going on and that the host knows you're there and can let you in, then as much as it is not a whole lot of fun, you should wait. Okay? Okay. So, do you have any questions right now?
Not at the moment. I don't believe so, no.
Okay, thank you. So, your next court date again, November 27th, 2024, 9 in the morning over Zoom before Judge Washington.
This situation did not arise in isolation. It is part of a recurring pattern. Previous hearings failed for the same exact reason: refusal to properly identify and participate. Judges are not obligated to indulge ideological objections to names or identity. When a defendant refuses to comply, the court must still move forward. Failure to appear is not excused by philosophical disagreement. Bench warrants are procedural, not personal. The consequences were entirely predictable.
24W001656.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Filt. Your Honor, when I did speak to Ms. Filt yesterday, she advised me that she did not want to be represented by the Public Defender's Office. Ms. Filt, could you say your name, ma'am?
Ms. Phillips, please state your name.
Yes. Shannon Phillips, the natural woman. On the record and for the record, and let the record reflect. Can you guys hear me? It's saying I have an unstable connection. Okay. Just making sure.
On October 9th, defendant was found in contempt of court. So that still stands, ma'am. You can choose not to have counsel if you want, but you need to understand that you can get up to 90 days on the contempt of court matter. Do you understand that?
I do not understand any charges. I only understand universal law and the right to live in peace and to live as I intend to.
But given that she doesn't understand,
Was never let in, just like now. But I obviously, I guess it took a minute. You administering the trust without consent?
I'm not going to be.
I'm having a bad connection. It's going in
I'm
and out. I'm
going
not
to be
hearing nothing
releasing
you all
the
are
public
saying.
defender's office from this case because I don't think she fully understands the consequences of her actions, and so she will continue to have the public defender.
I don't.
Judge Washington's courtroom operates with clear boundaries and expectations. She does not entertain sovereign citizen theatrics or circular arguments. Defendants quickly learn that performance will not replace compliance. Using a real name suddenly becomes necessary when consequences are real. The shift in behavior proves that compliance was always possible. Authority in court is not negotiable. This judge ensures proceedings stay grounded in reality.
Do you understand the laws of the state?
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied, ma'am. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness.
The charges?
You cannot make me have an attorney.
Well, actually, I can, ma'am.
Like, this is insane.
Well, I don't think it's me that's being insane.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction and expired plate.
Your Honor, I'd be happy to go into a break-in with Ms. Phillips and explain that to her.
Right. I will let you do that.
Thank you, Your Honor.
You're welcome.
Traffic and
The appointment of a public defender is not a punishment or an insult. It is a safeguard meant to protect constitutional rights. Courts intervene when defendants demonstrate a lack of legal understanding. Rejecting counsel does not eliminate the need for competence. The judge's responsibility is to ensure fairness, even against a defendant's wishes. Sovereign beliefs do not substitute for legal knowledge. This protection exists precisely for situations like this.
Leave on behalf of Ms. Phillips. Ms. Phillips, could you unmute and state your name, ma'am?
You have to unmute, ma'am.
Shannon Phillips, the natural woman.
Lebo, where are we with this, please?
Your Honor, I did have a discussion with Ms. Phillips. I did attempt to explain the importance of representation, why the court has asked that she have an attorney in this matter, as well as conveyed Mr. Barnett's offer. Ms. Phillips indicated to me that she still opposes having an attorney, additionally indicated to me that she is not, at this time, wanting to accept the offer of an expired plate.
Well, I think the offer was for a civil infraction of something different.
I believe was the civil plate infraction.
Oh, I see. Okay. All right.
It's improper plate.
What was the offer again, Mr. Barnett?
It was the civil infraction of having an expired plate.
All right, thank you. And not the criminal, not the
Correct.
criminal infraction. Okay. So, Ms. Phillips, that's correct. You're rejecting that offer.
There is widespread confusion, often intentional, about traffic law distinctions. Civil infractions and criminal charges are not interchangeable. What matters is how the statute defines the offense. In this case, the charge is criminal, regardless of personal interpretation. Courts do not rely on selectively quoted case law. Misunderstanding this difference can lead to severe consequences. Ignoring reality does not change legal classification.
That he's offering you the civil infraction of expired plate as opposed to the criminal offense of expired plate. One carries
Okay, but according to the Supreme Court, traffic infractions are not a crime. The People versus Battle. So, what criminal infraction? And I would just like for the case to be dismissed. One, because your who was it, Officer Hannah, and 3 more officers were surrounding my vehicle, pulling my door handles, threatening to pull me out of my vehicle.
Ms. Phillips, I'm going to advise
I don't
you
even
not
have the
discuss this
vehicle
further.
anymore.
Ms. Phillips, I'll take that as a rejection of the offer. What was
Okay,
your
so what's the
client
offer?
I'm
I
not
didn't
gonna
tell him
keep going in
anything.
circles with you now. Mr. Lebo?
Right, y'all just hate to hear the truth. Y'all just want to do what y'all want to do.
Ma'am, if you don't stop yelling out in court, you've already been held in contempt before. I'm going to hold you in contempt and give you 10 days in jail. Do you understand? Mr. Lebo, do you know what your client would want to do?
I do not, Your Honor. I did have a discussion with her, but she did not convey to me a desire to participate in that conversation.
All right. Then if she's not telling you, I will set it for a trial date.
Ms. Phillips, Your Honor, I would perhaps ask the court to consider a competency referral.
Nothing is wrong with me, you all. I am perfectly fine.
The prosecutor extended a generous offer that would significantly reduce consequences. This is often the best possible outcome in minor criminal cases. Accepting responsibility in exchange for leniency is routine. Rejecting such offers usually leads to worse results. Courts are not obligated to keep offers open indefinitely. Pride often costs defendants far more than compliance. This was a clear opportunity to exit the system cleanly.
And I do want to know that I did attempt to explain to Ms. Phillips why her understanding of the case law regarding traffic offenses was inaccurate, but that was not a productive conversation.
I could see why it wasn't productive. So, I don't know that she meets the level of incompetence to the standard that you're indicating. That if you want a referral, because you've talked to her and that's where you are, I will refer her for a competency. If she doesn't participate in that, then she'll be found in contempt or have to go to jail to get it done. So, her behavior here today is obviously taking her down a very dark path. Hopefully, she can change her mind and do something appropriate. So you either want to have a trial, ma'am, or you want to actually accept an offer. So those are your options.
We could take it to trial. We could take it to trial. We could take it to trial. We could take it to trial.
I heard you when you said it the second time.
Okay, well my screen is saying
The refusal to listen is not accidental, it is deliberate. Multiple explanations were provided, repeatedly and clearly. The defendant chose interruption over comprehension. This behavior frustrates judges and wastes court resources. Courts value efficiency and clarity. Ignoring information does not negate its existence. The consequences of not listening are entirely self-inflicted.
Trial and I couldn't attempt to discuss with Ms. Phillips a little bit further in the interim time.
All right. Because if she goes to trial and she's unsuccessful, it will be treated like any other criminal matter. So, ma'am, you do understand that you could get up to 90 days in the Washington County Jail, correct?
I hear you.
Retrial will be adjourned to January 8th, 2025 at 10 o'clock a.m. I'm sorry, 9 a.m. Do you have her contact information so you can talk to her so she fully gets what's going on here?
I do, Your Honor, and I would just ask the court if the court could repeat the pretrial date.
I'm sorry, repeat it. January 8th.
The difference between criminal and civil penalties is substantial. Jail time, fines, and permanent records carry long-term impact. Civil infractions typically involve only monetary penalties. This distinction should guide rational decision-making. Instead, ideology overrides self-interest. Many defendants regret rejecting civil resolutions later. At this stage, the warning could not be clearer. Next voice, next voice. The courtroom is not a place for alternate realities. Legal systems operate on statute.